Hi, everyone.
Okay, you may start.
Okay, hi, everyone. I hope you can hear me okay, and sorry for the connection problems earlier. Thanks very much for having me at this conference in a virtual forum. Unfortunately, I can't participate in person, but I hope you're having a good time and it's all going very well. I'm going to talk, hopefully fairly briefly, about another more theoretical engagement, more research-based engagement with themes of disruption, technology, and law. And it actually, what I'm going to talk about comes from a reflection piece that I wrote, I think at the end of last year, beginning of this year, published in the final edition of the Journal of Pure Production. I'm just trying to work out if I can share my screen. Okay, hold on. I'll do that later, so that I'll send a link to it later, so I don't disrupt my own talk. So really, what I was trying to do with this piece was think a bit about disruption and disruptions that we have encountered and continue to encounter in the field of law, technology, and innovation. And I guess, firstly, an apology. I've not been able to attend very much of this conference. So if I am making arguments that have already been made and I'm claiming that no one in our field really understands the broader picture, then please forgive me because it sounds like, from what I've heard already in this conference, there is very good discussion and theoretical engagement with a whole host of fields. However, I do think that in the field of law and innovation, particularly from a digital technology perspective, we have been a bit myopic about the idea of disruption. We have encountered, or at least the legal literature, particularly from the 1990s until fairly recently, I would say, has tended to view technological change as being disruptive. And I think a lot of this is to do with the fact that when the internet came in, there was a particular lack of understanding of the changes in technology that came from content industries. And those of us who've been around, I haven't been around quite that long in terms of legal academia, but those of us who've been around for at least the last 10 to 15 years will have kind of caught the tail end of some of these discussions and about the big battles that went on around piracy or infringement, a lack of adaptation by incumbent industries to the new technological reality, attempts to shove through laws that didn't necessarily reflect that new technological reality as well. And so I think there has been this discourse around disruption and around technology as being disruptive to law, which has some basis in the experience with intellectual property and digital technologies. I mean, the bad part of that, obviously, is the issues around the issues around infringement and a lack of willingness for various industries to evolve and change, and negative impacts on users. But there's also there's been positive aspects of that disruption. I mean, I won't go into all of them. I think a lot of them are fairly obvious, but we saw things like Creative Commons, the open source software movement really be galvanized by digital technologies. And these can be viewed as disruptive because they reappropriate intellectual property rights and licensing in ways that are non-proprietary, cooperative. They don't entirely follow the logic of kind of capitalist accumulation. That's all a bit of a prelude to saying that digital technology has been viewed as disruptive in the law, in a lot of law discussions. I use that tense of verb quite deliberately, because I think we are in the middle of a change about how disruptive technology may be or not. I think even the word disruption isn't really used as much anymore with regards to digital technologies. And what I did in this reflection piece, and what I have done in some other work as well, is think a bit more about what is disruptive, are these phenomena disruptive indeed, by which I mean, do they kind of fundamentally change notions underpinning the law, different areas of law, IP, data protection, for instance, but consumer law might be another example that I know Guido is working on. But is there kind of a fundamental challenge to the underlying principles and also practical operation of these areas of law? And I think that is an important question, given how much time, effort, energy has been spent on this idea that technology, in particular digital technologies, have been disruptive, but do they continue to be disruptive? I think a big part of the notion of disruption kind of inherent in the technology also came from a particular positionality. So a lot of the earlier work around internet law, which is only one aspect of law and innovation, don't get me wrong, I understand that, but that's the kind of, that's the background that I have. I think that in this area of law, so regulation of the internet, a lot of the people heavily involved were quite rooted in Anglo-American or Western traditions. Either that's where they were based, that's where they studied, or that's kind of their point of reference. And I think it's important to bear in mind the broader kind of political economy of the genesis of the internet and also its kind of early applications, really in a kind of deregulatory moment. So the idea that the technology is disruptive, another kind of notion to the idea that law has to follow technology, that the law cannot or that the law will always be outdated because of technological advances, I think is also related to this deregulatory moment in the 1990s, where there was a forbearance encouraged, particularly in Anglo-American systems, to proactively regulate a number of areas. And in fact, what we often saw as well was liberalization and privatization of industries like telecoms, on which the internet is based. So I think this whole idea of disruption shouldn't be so kind of technologically rooted, even as regards digital technologies, because of some of their history and the moment in which they were created. Other disruptions or potential disruptions, though, I want to kind of point to, which I think are increasingly influencing how we consider technology regulation, and also how we will consider it more in the future, from the recent past, from now, and for the future, are three in particular, or four actually in particular. So the global financial crisis of around 13, 14 years ago, rise of China as a major geopolitical player, the current crisis and disruptions brought about by COVID, which are still ongoing, albeit somewhat different from 2 years ago, and increasingly climate change as well. I think those of us who are working in digital technologies, of all of these, the ones that we may be most aware of are the rise of China. Many of us from Western backgrounds probably didn't pay much attention to China at all until probably the last 10 years. But I think increasingly it's impossible to ignore China as a major global player, but particularly in technology and increasingly in regulating technology as well. We can have a long discussion about what that looks like and what that means, but I think that has that in some ways is a disruption to ideas, particularly from an Anglo-American perspective, of how technology should be regulated. COVID, I don't think I need to say much more about that. We're all very aware of disruptions brought about by COVID and increasing reliance on digital technologies. But I think two things or two phenomena that we may need to take more account of are changing political economy approaches, somewhat rooted in the global financial crisis or flowing from that in the Western world, and also increasingly climate change as well. Now, I know I'm in the company of some people here, and particularly Professor Abby Brown, who has done lots of work around, so shout out to you, lots of work around intellectual property in particular and climate change. We also have discussions, particularly outside of law around, outside of technology law around climate change impacts, climate change technologies, but most of these are not really in dialogue with us in the law and innovation space, particularly coming from a digital technology background. There also are there is also awareness of the environmental costs of digital technologies, but I don't see a lot of this really permeating the law and technology scholarship at the moment, particularly digital technologies. So I suppose as some kind of summing up of this piece and kind of conclusion, I think there's a lot to say about whether any of these phenomena that I've mentioned should actually be considered disruptions. They might not be phenomena that have often been taken account of by those who work on the regulation and governance of digital technologies in particular, but that doesn't necessarily mean they actually are disruptions. And I think really the position that one occupies geographically, culturally, politically, etc., may make you view certain phenomena as disruptions because you kind of didn't see them coming, whereas they may not actually genuinely be disruptions. So I think maybe one conclusion or recommendation would be for us to have broad views of what is going on in society and the economy in general, globally speaking, even if we work on a tiny little piece of the law, innovation, technology, etc. Because sometimes these phenomena can kind of creep up on us and then they seem like a disruption when actually we should have perhaps been aware that something along these lines could happen. And of all of the disruptions that I identified, possibly the COVID pandemic is the most genuinely disruptive. But then on the other hand, we have had various people warning for quite some time that we were kind of overdue another pandemic. I think most of those people thought it would probably be a flu pandemic rather than a coronavirus, but I think even what might seem like a big disruption isn't actually, if depending on your view and understanding and knowledge. So I think in any case, we need to be kind of aware of all of these phenomena that are playing out and new phenomena that will play out, even if we don't think it necessarily is going to affect our particular area, because sometimes unexpectedly that can happen. And I think also to make sense of the world as it is, with a lot of change, technological, social, geopolitical, economic, we also need to be aware of all of these kind of different phenomena, again, even if we're not kind of specifically writing on it. And I think this kind of comes back though to ideas around kind of innovation, models of innovation, disruption, or even ideas of disruption, and the role of the law as well. Now, I hinted kind of earlier that I think we are seeing a change, in my view, in the last sort of 5 to 10 years around the role of the law in regulating and intervening in innovative markets or innovation technology. This whole idea that the law plays catch up to technology still exists in some quarters, but I think we're increasingly seeing the mobilization of law to shape certain forms of innovation, certain models of innovation in a more kind of proactive or interventionalist way. And I'm not offering a strong opinion on whether that's a good thing or not, but I do think that we are seeing more kind of proactiveness around using the law as a tool. And certainly recent developments, for instance, things like the GDPR itself, the EU's proposed AI Act, I think they aim to shape a certain vision of technology and innovation rather than letting that technology and innovation happen and then try and regulate it later on. They also do that as well, of course. I mean, data protection, digital data already exists in huge quantities. AI and machine learning already exist as well. But I think there is a kind of more proactive attempt to shape technology rather than it being kind of disruptive as such. Now, it's always good to end on a kind of 3 recommendations, but I think I might just leave it at that. And say, well, maybe the third recommendation too is also to adopt a more historical approach to some of these questions that we may be grappling with in our research. Now, I hope this doesn't seem like I want us all to be doing tons and tons more work, but I think just some awareness about how things may or may not have worked previously, and the trajectories of regulation, trends in regulation, also successes or lack of successes in regulation is important to bear in mind for working in this area as well, because there's a lot of incentive to look at the next cool new thing, what is very innovative, disruptive, whatever you want to say. There's also kind of incentives financially to do research in these areas as well, also to kind of increase impact, etc. That's great and good, but I think as academics, or most of us are academics, we should also have this kind of somewhat more of a historical perspective, or at least be aware that we're not necessarily reinventing the wheel, as it were, with every new kind of regulatory or technological intervention. So I suppose that I'll conclude on that. A historical approach, I think, is also important to really discerning whether something is genuinely disruptive or not, and looking at trends or lack thereof in technology regulation. Thanks very much.